friends, in the second, or rather in the previous video, I already discussed what is called business and what is called supply is going to be explained in now. As such, it's a very small chapter, coverage of few definitions, section 7, section 8 and read with schedule number 1, 2 and 3, right? Lots of explanation is given in the chapter, but that is only for reading. For remembrance, only section 7, section 8 as well as schedule number 1, 2 and 3. Okay. So now starting with the concept of supply, this is covered under section 7. And all the sections which are quote, these are from CGST Act, unless I tell you that it is IGST. So only CGST and IGST. Okay. So this is under CGST Act, section 7. And in section 7 also right now we are referring to subsection 1. This says supply includes. It does not say supply means. Supply includes all forms of supply that is sale, barter, exchange, rental, lease, disposal. So friends, when it says all forms of supplies, what is the main word is? These are the main words. All these are examples. When it says all forms of supplies, so these words used are only examples. Why these are examples? Because this says this is inclusive. So tomorrow if you happen to find a transaction which is not covered in these words by way of sale or barter or exchange or rental or lease or disposal, still it will be a supply, right? That's why it is inclusive and main words are all forms of supply. Now what do you call a sale? Sale in nutshell, this is transfer of title, for a price, right? I am not writing for consideration, this is for a price, and price is consideration expressed in terms of money. What is barter or exchange? Barter or exchange. In this case, consideration for supply is partly or wholly other than money. So either partly or wholly the consideration is other than money. What is rental or lease? Rental or lease. This is a transfer of possession for a specific purpose. Complete right of ownership is not transferred. What is transferred? That is a transfer of possession, and that too for a specific purpose, right? So here we said supply under section 7 subsection 1, this says supply includes all types of supplies, whether by way of sale or barter or exchange or rental or lease or whatsoever we call it. Then that talks about what is sale. Sale is transfer of title for a price. Then barter and exchange, that is consideration for the supply is partly or wholly other than money. And rental and lease means transfer of possession but for a specific purpose, right? This is one part. Now in section 7 itself we have, this is import of service. import of service, but this is for consideration. This is for consideration. Then here we have activities or transactions listed in Schedule 1, though the transactions are without consideration. So that's why we have to talk about Schedule 1 also. These are transactions without consideration, but still those are regarded as supply. So this becomes an exception to this, right? And then we have Schedule 2. In Schedule 2, activities are either supply of goods or services. So if there is a reason for confusion, in case of composite supplies, this defines whether it will be called as supply of goods or it will be called as supply of services. So Schedule 1 and 2 we are going to discuss little later, right? Now coming to subsection 2, this is section 7 subsection 1. This is all forms of supply, whether sale, barter, exchange, etc., etc. Now here you can add, if you want to add, this is in the course or furtherance of business. In the course of or furtherance of business, right? So little elaboration I'll give you later on. So subsection 1 says all forms of supply, whether by way of sale or barter or exchange or rental or lease or disposal, but in the course or furtherance of the business. Then import of service for a consideration. If services are imported without consideration but in the course of furtherance of business, those will be covered here. So these are not in connection with the business but imported for a consideration. So then the activities and transactions listed in Schedule 1, those are without consideration but is still regarded as the supplies. And then we have Schedule 2, these are activities which are referred as either as supply of goods or supply of services. Okay, now this is subsection 1. Now coming to subsection 2. What is given in subsection 2? That says that certain activities will not be considered as supply of goods or services. So certain activities are not to be considered as supply of goods or services. And in that, number 1 comes activities listed in Schedule 3. And number 2, these are activities of central government or state government or local authority as a public authority. So when government is doing any activity or government authority is doing any activity, it is already covered in the term, in the definition of the term business. But their activities in the area as a public authority, and if the activity is a notified one, then that will not be considered as a supply. Therefore, the question of taxability does not arise. So here you can add the word notified in the beginning itself. So certain notified activities of the central government, state government, local authorities, and in the capacity of public authority will not be considered as supply. So actually subsection 3 is also there, but that is not very relevant. So subsection 1 and subsection 2, these are relevant. In subsection 1 we said supply includes what, and subsection 2 says certain activities are not to be considered as supply. Those are the activities listed in schedule 3, and those are the activities by the central government, state government, local authority as a public authority, but the activities must be notified. Okay, so now you have understood what is called business, what is called supply. Now we go to the taxability. Taxability and this is under subsection 1. Subsection 1 is already in your notebook, right? So when the supplies become taxable, in that the very first thing is supply is taxable. So by chance there is an activity which is already listed in schedule 3 that is not a supply at all, and if any exemption has been allowed, then that will not be considered as a taxable supply. So you can say all the supplies minus which are not regarded as supply minus exemption, so therefore then what is remaining, that is a taxable supply. Number 2, supplier is taxable. Supplier is taxable. So in the chapter 1 I told you that the taxability begins when the turnover exceeds 20 lakhs. Before that there is no compulsion. So if before 20 lakhs the person is opted for being registered under GST and to pay GST, then he is a taxable person even before 20 lakhs, otherwise after 20 lakhs only. So first requirement is supply must be taxable. Number 2, supplier is also a taxable person. Number 3, the supply is for a consideration. To be treated as a supply under section 1, it has to be for a consideration in clause A, right? Without consideration, unless it is listed in schedule 1, it is not a supply. Number D, or rather number 4, this is in the course or furtherance of business. So when all these requirements are met, only then a supply becomes taxable under subsection 1, and that too clause A. In clause B we have a different story, that is import of service for a consideration, and whether it is in relation to business or not, that is also a supply, and that also attracts tax. Remaining 2 clauses, that is referring to schedule 1 and schedule 2. So this is important when the taxability is attracted. Number 1, the supply itself must be taxable. Number 2, the supplier should be a taxable person. Number 3, there has to be a consideration. Number 4, supply should be in the course or furtherance of the business. Only then taxability is attracted, otherwise not. When I said supply is taxable, so this is supply, all the supplies minus exempt minus which are already listed under schedule 3. Remaining thing will be called as taxable supplies. Okay. Now, moving further, since this section is talking about the schedules, now let us make a small list of the activities listed in schedules. This is not the exhaustive list, but I am giving you the main titles, right? So here now comes schedule 1. In schedule 1, number 1 we have permanent transfer of assets. Permanent transfer or disposal of assets. So even if it is without consideration, this will be treated as a supply. So here I will add provided input tax credit has been availed. Provided input tax credit has been availed. So any business asset on which input tax credit has been availed, if it is disposed of even without a consideration, it will be treated as a supply, and on that also tax will be payable. Number 2, supply between related persons. Now, who are related persons? That is explained under section 15. So I'll just give you a reference. The formal definition we can refer when we come to section 15, or you can refer the material that says when the two individuals happens to be officer or directors in the business of each other, or they are partners in business, or they are principal and agent, or you can say employer and employee, or these are two bodies corporate in which at least 25% holding is held by a common person, or one controls another, or both are controlled by the same person, or both are controlling a third person, or they are members of the same family. Right? You can read the definition of the term related. I'm just repeating it. They are officers or directors in the business of each other. They are partners in business. They are principal and agent, or employer and employee. Next is both are bodies corporate and at least one person holds 25% voting power in each. Then one controls or owns another, or both are controlled by the same person, or both of them together control a third person, or they are members of the same family. So if there is a transaction between related parties, even if there is no consideration, still it will be treated as a supply. Then number 3, this is supply between distinct persons, and this is as per section 25. Under section 25, registration is required to be taken separately for every vertical of business and in every state. So maybe one person is having business in Maharashtra, he is also having business in Gujarat, he is also having business in Rajasthan. In all 3 states he requires a separate registration, and for the purpose of GST, every such person will be treated as a distinct person only. Though all those are under the ownership of the same person, that is okay, but since those are separate registrations, so you can say that every registration, it means a distinct person is there. So supplies between those distinct persons will also be considered as supply for the purpose of this tax. Then number 4, stock transfer from one place of business to another place of business. Then transfer of the stock between branch transfer, goods being sent from the factory to the branch for being sold therefrom or for being supplied therefrom. So when the goods are supplied from the factory to the branch, certainly there is no consideration, but for the purpose of law, that is also a supply. And friends, what is the main objective behind this? If you understand that, you will not ask any more questions. The objective is simply paying the tax at the initial stage and then transferring the credit to the another person. So when the goods are being transferred from the factory to the branch, and the factory pays the tax and the branch avails the credit, and the branch can pay the tax when the further supplies are made therefrom. So the sole objective of all this is to transfer the credit from one person to another. Otherwise we don't have any such system under GST where the credit can be transferred. Then similarly, between principal and agent, goods being supplied by the principal to agent or by the agent to the principal, again that is also a supply even if it is without a consideration. Then import of service, and in case of import of service we said without consideration, so that will become relevant only if it is used in the course of furtherance of business. So number 7, import of service. Now if you refer subsection 1 in subsection 1 clause number B, we said import of service for consideration. Now whether it is used in business or not, that is immaterial, that is a supply. But here we are talking about import of service, but this has to be in the course or furtherance of business. In the course or furtherance of business, right? So friend, these are the activities listed in schedule 1. And what is schedule 1? These are the transactions which will be treated as supply for the purpose of GST even if it is without consideration. I hope you have already taken a note with me. Number 1, permanent transfer or disposal of assets but provided input tax credit has been taken. Number 2, supply between related person. Number 3, supply between distinct person as per section 25. Number 4, stock transfer. Number 5, branch transfer. Number 6, transfer of the goods or services between the principal and agent. Number 7, import of services without consideration provided those are used in the course or furtherance of business. So this is schedule 1, right? Now let us move to schedule 2. So for schedule 2, let us remove this. In schedule 2, we have certain supplies which are declared by the government to be treated as supply of goods or supply of services, right? So quite possible there may be a reason for confusion, and the purpose of giving schedule 2 is avoidance of any kind of dispute or litigation. So whether it will be treated as supply of goods or supply of services, because in certain cases both are involved. But in schedule 2, activities have been clearly defined that if this is the transaction, it will be treated as supply of goods. If this is the transaction, it will be treated as supply of service. So in that, number 1, transfer of title of goods. Title of goods. Now whether it is immediate or this is in future. Future means it is a case of hire purchase agreement. This will be certainly a contract of supply of goods, right? I'm not talking about leasing, I'm talking about hire purchase. So in case of hire purchase, the title is transferred at the end of the last installment. So as of today it is not being transferred, but it will be transferred in future. But for the purpose of GST, from the very beginning it will be treated as a supply of goods, right? Then it is transfer of possession. Transfer of possession of goods for a specific purpose. This is called as supply of service. Here the title is not being transferred, exclusive right to use is not being transferred. What is transferred is possession, and that too also for a specific purpose. So rentals are covered here, lease is covered here, right? This is hire purchase. So if you wish to have the addition therein, you can say this is hire purchase, right? And these are this is the case of this is the case of leasing as well as rental both. Then comes about the land and building, right? Number 3, let me put building. No, land is also covered therein, sorry. Land, in case of land, that is only transfer of possession, same, that is for a specific purpose, it is a transaction of service. So land can also be rented out, but if it is an agricultural land, that will go under exemption. Number 4, in case of building, this is lease or rental. This is a service. Right? Now in this we can add something more as far as construction is concerned, but on that we'll come little later. Then comes processing of goods on behalf of another. Processing of goods for another. So this is a job work. Job work will also be considered as a service. Right? I hope you are noting with me. Number 1, transfer of title of goods either immediately or in future, that is a supply of goods. Transfer of possession of the goods but for a specific purpose, no rights of ownership are given, that is a contract of service, supply of service. Land, it is again temporary transfer of possession, it is a service. Temporary transfer of possession of a building, that is also a service. Processing of goods on behalf of another, that is also a contract of service. Right? Now number 6, business goods put to personal use. This is also a supply of service. So company's car being used by the director for personal purposes, and for that he is paying a rental to the company, then it will become a supply of service. Right? And if the business goods are transferred for personal use, those are transferred, that will become a supply of goods. Then in relation to construction, number 7 requires little more explanation. This is construction, and in construction also it is intended for sale. In this case, any part of consideration received before completion certificate, and this is later. When the agreement is signed or registered, that is immaterial. Question is, the seller is receiving the consideration either partly or wholly. But at what time? Before receiving the completion certificate or after receiving the completion certificate? If this is the case, it will be treated as a supply of service. Though the major part is goods, but it is treated as a supply of service, and if it is later, it will not be considered as supply for the purpose of GST. In the first lecture, I told you that in relation to construction, if the completion certificate has already been obtained, it becomes immovable property, and GST is not applicable in case of immovable property. Right? So that was about construction. Then intellectual property rights. Intellectual property rights. If these are temporarily transferred to another person for use, certainly in connection with business, it will be treated as a supply of service. So intellectual property is copyright, patent, trademarks, etc. Then we have softwares. So any activity in relation to software, so whether it is development or modification or adaptation, whatsoever it may be, any activity in relation to software, it is treated as a service, right? Then tolerating nonsense, that is just one word, nonsense, or it is refraining from taking any action. So when a person agrees not to do something on the will of another, it is also considered as a service, right? So these are the activities listed in Schedule 2, which are defined as either contract of, or either it is a supply of goods or supply of services. Now herefrom we move to Schedule 3, listing of the activities or transactions which are neither considered as supply of goods nor considered as supply of services. Okay? In this itself, we have now Schedule 3. Schedule 3. Number 1, activities by employee in ordinary course of employment. So when there is a contract of employment, there is a remuneration or there is a salary involved, so that is not considered as a supply of service for the purpose of GST. But anything over and above the salary or remuneration, then comes gift. Gift by employer to employee. By employer to employee, up to value of rupees 50,000, up to value of rupees 50,000 in a financial year. This is also not considered as a supply. If the value exceeds, it will become taxable. Then comes activities of members of parliament, members of legislative association or authority, or you can say local authority or panchayat or board, local authority, municipal corporation, or development board. They are entitled for certain salaries, but there is no contract of employer and employee like this. So that's why those are listed separately. In this itself, it is further said, any person holding any constitutional position, like President of India, Governor of a state, constitutional positions, who they are entitled for a salary, but still it is not considered as a supply. Similarly, office of chairperson or member, office of chairperson or member of any government body. Best example is SEBI. Any person who is appointed as a member of SEBI, he becomes a full-time employee, but still it is not considered as a supply of service. Then number 3, services or activities by court or tribunal. Then number 4, services related to cremation, or you can say last rite of a person, burial. These are not considered as supply of services, right? So this is schedule 3. Okay, so friends, in this chapter what we have talked about, we talked about few important definitions in the beginning, then section 7, then section 8, and then schedule 1, 2 and 3. So section 8 is remaining, but just I'll brief that in 2 minutes. So now coming to section 8, and that is more about classification of the supplies. Section 8. So this is referring to 2 types of supplies. One is naturally composite supplies. So person is staying in the hotel, stay facility given along with fooding, naturally composite services. And here we have artificially mixed supplies. So these supplies which are not common, but somebody agrees for the supply, then it becomes an artificially mixed supply. In this case, taxability is based on principal supply. Say a cargo company agrees to pack up, load, transport and deliver. In that activity, main is the transportation. So that everything will be based on the basis of principal supply, that is transportation of goods. And in this case, wherever taxability is higher, wherever taxability is higher. So by chance, if somebody is selling a mixed bag of number of articles attracting different rates of GST, so when it is sold as a pack, it becomes a mixed supply, and on the entire pack, tax will be based on the article where the taxability is highest possible. So friend, this is section 8. Okay, so complete notes now are there in your notebook. Revise these notes and then refer the material, or if you have already referred that, now what I suggest is that after going through all these notes, do refer the illustrations as well as question answers given in the material. Thank you.